Welcome to Vampire Divorce with Attorney Clarke Young.
Hey everyone, welcome into an all-new episode of Vampire Divorce with Attorney Clarke Young. I am your host, Mike Leon. Clarke here is a seasoned family law attorney, consultant, and expert witness who helps courts and families navigate the realities of high conflict custody cases. And in today's episode, we're going to be talking about why borderline custody battles are rarely about parenting and are instead about power. Clarke, it's good to see you. Let me ask you about these high conflict custody proceedings that involve a parent, right, who suffers from borderline personality disorder. What have you seen that makes it clear to the court or any other observer that the dispute isn't really about parenting, normal child development, or the best interest of the child?
First of all, Mike, thanks for having me again. This is actually a real central question in all of these borderline personality disorder cases. Um, the courts and most of the participants in the system are focused on the law. They're focused on demonstrating to the court, which parent is better able to meet the children's needs. And depending upon what state you're in, there'll be a statute that describes the different elements, different considerations that the court's supposed to uh, consider in making the determination. And that works in the garden variety cases, but in the borderline world, the narcissist world, it's really not about the best interest of the child or about parenting as much as it is about just the power dynamics that are going on, the power struggle that's going on. At some level, the courts are very much and perhaps even painfully aware of the power dynamics, but they're trying to almost ignore them or get through the power dynamics to get to what they think is the core of the case. And that's kind of not really what happens because, as I've said before, when you have a case where there is a moderately severe or severe personality disorder of any kind, the conflict is not going to resolve itself until and unless the court addresses that psychological pathology. So, where you have the DSM-5 cluster B personality disorder cluster, which is what it's called, um, the antisocial behaviors, the histrionic behaviors, the narcissistic, the borderline behaviors, things like that, uh, you are always going to be involved in a power struggle in these cases. And that's really, to get to the heart of your question, how do you make it clear to the court or any other observers or any other participants in the divorce or child custody proceeding what's going on? And that is something we've talked about throughout the series. And it really comes down to perhaps finding, well, first step is you've got to educate the court to help them get to a point where they're actually willing to, where they feel it's necessary, where you convince them that the psychological dysfunction that's driving the conflict is something that they have to address. That's like the number one biggest hurdle. Once you get over that hurdle and they appoint a psychological evaluator of some kind, that's the second hurdle. Again, for that sort of situation, you have to find somebody who is actually has the education, the skill sets, the experience, the background, the training, the degrees, the certifications that are necessary, and I mean absolutely necessary, to understand and actually see and analyze the borderline aspect or the narcissism aspect of the case. So that's the second major hurdle. You've got to get someone good. And then after you do that, then you have the third hurdle, which is taking that expert testimony, going back to the court and getting the court to understand that the diagnosis itself is identifying a parent who is not a reasonably adequate parent, which is the standard in California. Then the fourth hurdle is going to be coming up with some sort of a conditional custody order or a parenting plan in which the pathogenic aspects of the pathological parent are somehow monitored and mollified or controlled somehow. And that order that you're going to get is probably going to end up being sole physical and sole legal custody for the normal range parent. Because at the end of the day, the court doesn't want to be monitoring or every step of the way. They don't want to, the parties don't want to be paying to have someone monitor the pathological parent's parenting time every day they have parenting time. So the courts ordinarily will default to, we're going to let the normal range parent make major decisions concerning the children and some minor decisions, as long as it doesn't overall modify the parenting plan that's been ordered.
Clarke, let me ask you, because you mentioned about a typical case, for lack of a better term, versus PPD case. How can you kind of explain a little bit more of how does that fight for control in that case play out compared to an ordinary custody dispute between two normal range parents?
Oh, that's a good question. So in a normal range, a garden variety custody proceeding, you're going to have two adults who have decided to separate and go their separate ways for whatever reason. Um, in those cases, let's assume hypothetically that it's going to be a case where there's been some real mistakes made, or there's been some real hurt feelings. There's been some damage to that person. Nevertheless, a normal range person is going to have the resilience and the maturity and the tools and the willingness to get the help they need to deal with the transition they're going to go through. And over time, um, as each of those partners get the help they need and they begin to heal, the conflict in the case will go up and down periodically. Sometimes someone is involved with a new mate, and that causes problems like, well, who's going to be parenting this child when they're with that parent in that home, things like that. There's always those sorts of problems. And that's a normal range conflict where the power play is not really so much unconscious and compelled as much as it is sort of a normal reaction to a difficult situation. So their use of power is going to be more defensive and more protective of the children, and more of a a defense mechanism, if you will. But that is not the universe I'm talking about. That's not the borderline or narcissist universe. That's not the cluster B power play that we've talked about before, where you've got power, control, manipulation, and deceit all being employed as a means to subjugate the other party and the children and everybody else in the child's world to their will. This is a fight to the death struggle. And it's the sort of struggle where the borderline will force an all or nothing outcome on every issue, but mostly the custody issue, because they know they're right, they know they're perfect, they know what's best for everybody in the world, and they're going to fight to get that, even though everybody in the room knows that what they're talking about and the results that they want don't even make sense after a while. So, ironically and sadly, the borderline will self-sabotage, and if you can stay in the game long enough, the normal range parent normally will, with a decent court, get close to sole physical, but at least primary physical custody, and has to be sole legal custody. Otherwise, the conflict is just going to rage. The power struggle is going to continue. So, in summary, when the court realizes that there's this to the death power struggle going on, they'll also have to realize they have to take the power away from the person who's going to abuse the power unconsciously and in a compulsive way, and give that power to the normal range parent, who then is going to have to basically manage the family on their own.
Clark, let me stay on the court for a second because obviously the family court system is truly like a game, and I know it encourages cooperation, et cetera, conciliation. But why does the court focus so much on that? And why, in your estimation, or do they, you can answer, do they miss the true psychological dynamics that are at work?
Well, part of this answer has to do with the sequencing of how the court system is set up, and you come in and you take step one, then you come back later, you do step two and three, and so it's a very sort of check the box sort of system. Well, to me, that's sort of a Twilight Zone episode because in real life, these people are in the middle of the struggle. They're not at the beginning of it. Second point, the judge doesn't know anything about your case when you walk in on day one. So they're going to lean heavily on the systems they've ensconced and to get them through this process somewhat logically. Meanwhile, there's a battle raging outside. So what ends up happening in this case is the court's going to focus on, I call it kicking the can down the road. They're going to say, have you been to mediation? Do you want me to send you to a settlement judge? Or let's send you down to the office where they have some people that have a bachelor's degree in psychology, and in a half an hour, they'll analyze your case and give me a recommendation on custody. And it's in these kinds of cases, that's insane. Does it work for normal range divorces and paternity and child custody proceedings? Well, maybe sometimes. But even in those cases, it's not the best or most experienced people. In the borderline universe, it's a disaster. It just empowers the power plane, borderline, and it depowers and takes power away from the normal range parent who's trying to really protect the children. So you end up getting a situation where the courts end up being enablers to some really horrific child psychological abuse and child neglect, really. But they don't see that way, of course. They think that they're the white knights in shining bright armor that are riding in to save the family. But the system isn't set up to deal with borderline cases. So, unfortunately, unwittingly, and certainly unintentionally, the courts are, as I've said before, destroying America one family at a time. So when you get down to the settlement, and you get two messages, and this happens in every case, by the way. You go in, and the judges will actually lecture you on, you don't want me making this decision for you. You two should, put on your big girl and big boy pants and make a decision and come in here with a settlement offer because, you should be able to agree on this. If you can't, we're going to try and get someone else to do the job. And it only delays the inevitable, which is borderlines can't settle. They just can't because they know they're perfect. They know they're fine. They know they're right. They know it's best for everybody. And to ask them to compromise is like admitting that they're not perfect beings, and that's never going to happen. So I hope that answers the question of why it is that, on the one hand, the courts are promoting settlement. Again, they're also checking those boxes. Did you do this? Did you do that? Did you take a parenting class? Did you do your anger management class? Did you do all these things?
Right.
But in the reality, it's an adversarial system. And you have to be very careful because if you have a naive client who thinks that it's going to settle, you still have to be preparing for war because 99 times out of 100, it's not going to settle.
Well, Clark, talk about the shift then. The court now recognizes that it's a borderline against a normal range parent. Like, what's the shift now that it's understood by the court? Is there a shift?
Well, there is a shift in almost every case, and it may take a year and a half or 2 years to get to that point. But at some point, the light will go on, and the judge will realize the case isn't going to go away until they actually deal with the elephant in the room. And when that happens, then suddenly you refer back to the day in the life declaration that you filed on day one, where you described how the borderline abuses you or your clients. You're the normal range parent, how the borderline abuses the children, and the parenting isn't very good, and the judgment is so poor. And you suddenly, all those things are not seen as an angry spouse talking badly about the borderline. It's just someone being descriptive about this is my living hell. This is what I do every day. This is what I have to put up with. And when that light goes on, well, suddenly you get the custody orders that you needed back a year and a half or 2 years before. And in that 2 year period, the child has been psychologically maimed and probably traumatized for life. And if it's the same sex child as the borderline, they've been imprinted for 2 more years with the borderline imprint. And they're probably doomed for life anyway at that point, sadly. But at least you get the judge to start to say, I get what's going on. I'm going to give sole legal custody to the normal range parent. I'm going to give primary custody to the normal range parent, and I'm going to give some sort of monitored or conditional parenting time with the borderline parent. So that order might say something like the borderline parent needs to be in therapy. There might actually be a monitor or someone monitoring the behavior. Depending upon the age of the child, if the child is old enough, the child can self-report about what happens when they are with the borderline parent. And there are certain modifications can be made. Ideally, this rarely happens. I rarely get this result, but sometimes you actually get a judge that will say, normal range parent, it's your family. You manage this person the best you can. If you need my help, file a motion. But in the meantime, if the borderline is having a flare up, having a bad day, you have the authority to go get the children, bring them back, and then when the borderline is having a good day, let them make up some of that lost time, so that the custody order that says they get 20%, say, is fulfilled in spirit, even though we're not rigidly applying a week-to-week schedule like the courts normally do. I'm giving you discretion to move off of that normal range as long as you keep a calendar and can show me that they get 20% over time, but you are interdicting it when the borderline has a flare-up, a borderline flare-up I call it, and they are mistreating the children. So that's the ultimate goal that you're looking for.
Right. Clarke, as we wrap here, for the parent that's still trying to reason their way through these cases, what would you want them to understand about why the logic and goodwill portion don't really resolve that power-driven conflict that you've mentioned?
That's a really good question, because I think all family law attorneys get clients who come in, and I'll just say I think they're certainly naive about the legal process, but they're even somewhat naive about their situation or how it should be solved. They're not naive about what they're dealing with, though. Uh, but they come in with hope that they're going to be able to settle this, or it won't cost very much, or is there a shortcut, or maybe my case will be different. It's not. So when they come in with that, let's be reasonable. That is a paradigm that I can use with them and talking to them what we need to do, the steps, the goal, how we're going to get there. But I need to remind them that they're dealing with someone who is totally irrational.
Right.
And these cases always proceed on the least common denominator between the parties, their attorneys, and the judge. So if you get a court where the judge is the lowest common denominator,
Right.
you've got to deal with the case on that level. If you have an opposing counsel, say, who's also a borderline, and so you're dealing with a borderline who is a borderline client, you're basically marching into hell on that one, because those are impossible cases to really litigate.
Yeah.
But again, everything devolves to the lowest common denominator. So your client when you say to them, you shake them up and say, wake up, what are you talking about? You've been living with this person for 3 years or 20 years, whatever it is. You know that you can't reason with them. Why do you think something's going to change now? In fact, it's going to be worse, because you're in a system that is going to empower them and disempower you.
Right.
So once they come to the realization that logic is not the name of the game, then they become more flexible and they become more understanding. And in a lot of the cases that I do, at the end of the day, the solution doesn't even happen in court. We are able to checkmate the borderline out of court. And there are some techniques for doing that, and they're very, how can I say, I'm going to call them proprietary, because that's not something I want to put out there for all the borderlines in the world who watch this to understand how to circumvent,
Right.
information and experience that I've garnered the hard way through many years of doing this.
Yeah. Clarke, thank you so much for the time and the insights and breaking this all down for the audience, as always. I appreciate it.
Thanks for having me again. Good seeing you.
That's it for today's episode of Vampire Divorce. If you want to learn more, you want to connect with Clarke, do me a favor right now. Visit clarkeyoung.com. You can get all the information there. You can connect with Clarke and his team. Thank you again for listening. But before you go, hit like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I am Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.